Special weekly daily list for judgment item number 1, CRA 94 of 2001 and batch of matters.
We will have the appeals. The appellants are all acquitted. The bail bonds stand discharged.
Item number 2, WPC 5888 of 2011.
The writ petition is without merit and is dismissed.
Item number 3, WPC 26692 of 2011.
We've allowed the writ petition and we've said that arrears will be paid to the petitioners within a period of 12 weeks.
Maybe pardon me, Lord.
Number 4.
I filed a list of events. Both connected matters are there. I filed a list of events. I am assailing the order of recovery dated 31/3/1999 under Annex 3, passed by the board. There's a Orissa State Water Supply and Storage Board. Here, that recovery is based on the labor escalation, which we have already paid in a concluded contract. On 28/8/92, work order accepted. Upon negotiation, work order was issued.
All
And the
these are
nature of
contractual matters, sir. You file a writ petition for all contractual matters. The
Yeah,
whole problem.
I'll just place.
You have filed a suit for recovery
I'll
arising out of a contract, correct?
place my facts. I'll conclude my hearing. If your lordship may grant me some time,
Basically, you're saying don't ask me questions.
not that. not-
That's what you're
not
saying.
that, just
Don't ask me questions. Let me just argue. You're saying.
no. Just I
We
want.
don't mind that. We will not ask you a single question. You go on arguing.
We don't want that.
No.
Your lordship
If
can
that is
allow-
what you want, you will get that.
the lordship allows me some time. I'll
No,
just,
we'll allow you
I'll
any
satisfy.
time. Don't, if you're trying to say, don't ask me questions,
No,
we'll
not
take
that,
it.
no.
We will not
No,
ask
no,
you
no.
even a single question.
No,
Ah.
not.
No question will be asked. You argue. You argue.
I'm sorry. Ma'am.
Don't be
If-
sorry.
If
Don't be
anything,
sorry. You are allergic to questions, so we accept that.
no. I just argue.
It's all right. It's all right.
Here, the nature of work is that to supply raw water to a town or city, and those work are the nature of work that is defined under. We have said at page 2, annex. Sorry. Para 4, we have said page 3 of the writ petition, and also there in the annexure 1, page 9. That is for major supply of raw water to different sites through pre-stressed concrete pipes of 500 to 1000 millimeters die. Here, 12/8/92, an agreement was executed by the parties. And the cost of work I have mentioned, my lord. And the agreement had a clause under 33B for labor escalation. I'll just place that clause. Para 7 of my writ petition. Clause 3 provides, similarly, if during the progress of work, the wages of labor increase or decrease as a result of increase or decrease in the average consumer price index for industrial workers. That's the wholesale price. And the contractors thereupon necessarily and properly pays in respect of labor engaged on execution of the work such increased or decreased wages, then he shall be entitled to reimbursement or liable to refund quarterly as the case may be. Such an account as shall be equivalent to the plus or minus difference between the average consumer price index for industrial workers, wholesale price, which is operating for the quarter under consideration and that operated for the quarter in which the tender was opened as per the formula indicated below. There was a formula to that effect, provided that the work has been carried out within the stipulated time or extension thereof as are not attributable to him, and the formula is indicated, my lord. So basically, the labor escalation of clause 33B was based upon increase or decrease in the average consumer price index for industrial workers. The government's counter is it should be based on minimum wages. And after conclusion of the contract, government had taken some decisions or through instructions on the opinion of the law department, which they want to impose that by way of notice of recovery. And the conclusion of the contract and the commissioning of the work has been successfully maintained, supervised under the direct control of the board for 1 year compulsory. Your Lordship must see 7/6/97 work was completed and handed over. As per the contract, 7/6/1998, this is 1 year, which was maintained under their supervision and control. And this is being successfully commissioned from that day itself, 98. This has been admitted by the board in their counter also. Work has been concluded. At Annex 7 of my rejoinder, if this honorable court may see, on 23/3/99, member secretary wrote a letter to the law department to consider the recovery towards escalation in absence of any provisions in the agreement. They knew that this was not a part of the agreement regarding this escalation of minimum wages, the circular, the instruction of the government on the opinion of the, based on the opinion of the law department, which are all foreign agency to the agreement itself. An agreement that agreement had concluded since 1998. And this notice of recovery was made on 1999. There itself they have come up, and the notice of recovery does not disclose based upon what instruction of the government they want to recover that amount. That I'll take an honor to page 19 of the brief, Annex 3. Can I place it? The impugned order. It is observed that excess payment of rupees 52 lakhs amount only has been made to you on account of escalation of labor components for the above noted work, which we have paid that part. In this connection, senior audit officer of AG Orissa Bhubaneswar has pointed out certain excess payment on account of escalation and labor components. Basing on the works department, Government of Orissa letter number such and such dated 28/1/91, 28/10/91 and 27/11/92 and 17/12/96 communicated in the Chief Minister of Roads, Orissa Bhubaneswar, in his memo dated such and such. The board of, as per the opinion of the law department, Orissa, that no payment of escalation as per the average consumer price index for industrial workers should be made where tenders have been floated and finalized after 1/9/1990. This is completely afterthought, this part. And this is totally a foreign element in the agreement itself when the agreement has been concluded. And what is the source of this? At page Why they have come to this conclusion for this? Can I take to page 21 of the counter filed by the board? Page 21, then annexure B. Annexure B, page 21. Are I place it? Here, it is a Works Department letter to the Chief Engineer Roads, National Highways and Buildings. Page 21, Annexure B, filed in state government board's counter affidavit. I am direct to say that the consequent upon the revision of minimum wages with effect from 1790, a good number of contractor associations of contractors, etc., executing road, bridge, and building works under the Works Department pointed out that the existing escalation clause for reimbursement of increase in the cost of labor is based on average consumers price index for industrial workers wholesale price, and the same would not suitably compensate them for the hike in minimum wages, etc. That is from rupees, they have quoted the rate. They accordingly requested that their difficulties might be favorably considered by government so as to suitably compensate them for the wage hike. And the government are pleased to approve the following last line, guidelines for assessment of the escalation charges on account of it. In this letter here, I was not a party to this contractor association, which I have taken in my rejoinder. I was not a party. And here it is for roads and building. The Lordship is executing road, bridge and building, not for water supply. So we are not a party to this. And based upon this and the law, opinion of the law department, they have said that the minimum wages shall be applicable. At page, I'll take a lot of page, annexure 7, page 11 of the rejoinder. I filed their document. Annexure 7 of the rejoinder. Here, the board has requested the law department to consider this effect. I'll just place the relevant. In this connection, it is to state that since DTCN detailed notice of these works and subsequent F2 or LS contract signed with these contractors did not contain either the copy of the letter dated 28/10/91 and letter dated 27/11/92 or 27/12/96, nor the opinion of the law department at page 11 of my rejoinder. That is their document. It may kindly be considered if recovery of escalation charges on labor company in respect of contracts finalized after 1/7/1990 and up to 96 could be recovered in absence of any provision in the agreements. If recoveries are reflected, it is likely that some of these contractors may go to the court of law for orders. This was in 23/3/1999. And on 31/3, this notice was issued to me, demanding a recovery of the amount. When my outstanding bill was pending, I have stated in 23, notice of recovery was made. Then on 15/4, I had my date chart, 15/4/99, I objected to the said recovery. Annexure 4 and 23/4/99, I have given the detailed outstanding bills which are pending with them for payment. Thereafter, 17/5/99, reminder to release the outstanding bills were made. And in 26/8/2000, land was handed over to the board, which we had taken to construct this work order. So the decision is completely a foreign document to the agreement already signed, executed, and concluded in 1998 itself. So any decisions or instruction of the government is an afterthought, and for which the petitioners are seriously prejudiced. Hence, the recovery is arbitrary, illegal, and void. The decision making process for arriving at such decision is arbitrary, unreasonable. I will just place some citation. You will also be perfect. Other matter is also same, but that's a Sambalpur work. I have quoted all the judgments. The first judgment itself, I'll take your lordship to para 12. First judgment, para 12. Para 12, last para. I'll place it. Para 12, last line. Even though the rights of citizens are in the nature of contractual rights, the manner, the method, and motive of decision of entering or not entering into a contract are subject to judicial review on the touchstone of relevance and reasonableness, fair play, and natural justice, equality and non-discrimination in the type of transactions and the nature of the dealings as in the present case. Last line of para 12. Then para 13, first line, the existence of the power of judicial review, however, depends on the nature of and the right involved in the fact and circle of the particular case. Then at para 18, my lord. Para 18 in the middle, change of policy, and on the basis action to seek to bring to an end the course of transaction over 18 years involving large amounts of money is not fair action. Then the next is that this judgment of judicial review is not against the correctness of decision, but against the correctness of the decision-making process. And at serial number 3, the third decision, third decision, para 10. Para 10, last line. The court can strike down an executive order if it finds the reasons assigned were irrelevant and extraneous. the courts are more concerned with the decision-making process than the decision by itself. And at serial number 4, paragraph 22, that is citation number 4, paragraph 22, at page 8. Though there is one set of cases rendered by this court of the type arising in Radhakrishnan Agarwal's case, much water has flown in the stream of judicial review in contractual field. In cases where the decision-making authority exceeds power, statutory power, or committed breach of rules or principles of natural justice, in exercise of such power, or its decision is perverse or passed an irrational order, the court has interceded even after the contract was entered into between the parties and the government and its agencies. And the next, serial number 5, is para 19, serial number 5, citation number 5. Citation number 5. I also quoted the paragraphs. 19, paragraph 19. It is clear from the above enunciation of law that merely because one of the parties to the litigation raises a dispute in regard to the facts of the case.
Lord, here the Orissa Water Supply Storage Board is the opposite party, Lord. I am recently have been engaged by the board, but the case pertains to 2010, Lord. But Lord, what I find, Lord, there is one direct judgment of this honorable court where this issue was clarified, and Lord, just handing over this.
Involved.
Amount being, court leaves the questions of law open. Right.
Special week list item number 6.
None appears this is not discussion.
Special week list item number 7.
My lord, item 7 and item 11, no instructions.
No instructions. All right. Disposed of this section.
Special week list item number 8.
None appears this is not.
Special week list item number 9.
None appears this is not.
Special weekly list item number 10.
None appears this is not.
Special weekly list item number 12.
My lords, for this SSC for different years, my lords have disposed the matter on 13/4/2022. That rectified spirit has to be incorporated in the RC matter.
All right.
Obligation. I'm passing
Just
on
give us
the
the STRV number.
I'm passing on the slip.
Yeah.
161/2007.
All right. In view of the order passed on. present revision petition is disposed of in the same terms. Order passed on 18th April 2022 in STREV number 161. Order dated 13th April 22 in STREV number 161 of 2007. The present revision petition is disposed of at the same terms.
Mobilization.
Good.
Special legislative item number 13.
None appears disposed of.
Special weekly list item number 14.
Item 14, my lord, it has become infructuous
All
because
right.
the writ application has already been disposed of.
All right, sir. Constable petitioner states the petition has been printed and disposed of as such.
Special weekly list item number 15.
Item 15, 674 days delay.
There's an unexplained inordinate delay of 674 days in filing the writ appeal. The court is not satisfied with the explanation offered for the delay. The application is dismissed. Accordingly, the writ appeal is dismissed.
Special weekly list item number 16.
My lord, pray for a week's time.
For what, sir?
Lord, the defect is pointed out.
Not now, sir. It's 2011 matter.
My lord, 2011 matter, defect is pointed out in 2022, my lord.
That's all right, sir.
There are only certain matters to ascertain from university.
Not after 11 years, sir.
1 week may be granted.
No, sir. Sorry. Sorry, sir. Please proceed with the matter. Kindly proceed, sir.
If the certified copy is not granted, defect is to be removed.
I know, sir.
My lord,
It's 11-year-old matter. That's why.
in the file, I have got the Xerox copy. So I think certified copy must have been
You can
filed.
still argue, sir. We'll presume that the defect is cured. Please argue it on merits now.
What I submit for your lordship's consideration, only ascertain certain facts so that I may remove,
Sir, we are presuming that there are no defects. Please argue the matter now.
but if your lordship permits me to argue the case.
Yes,
argue the
yes.
Case, my lord.
Hello.
The order dated, I have challenged, dated 19th January, passed by the single judge,
2000, when, sir? 2000 and?
2021.
No. The impugned order, sir. The date of the impugned order.
Impugned order is 19th January 2011.
Ha.
But I have challenged that in the court, I have said that the college is not an affiliated college nor an admitted college. So, no permission can be granted for admission of the students because it's not affiliated to the university. Under the Education Act, it is not also accepted, admitted by the government.
What is the relief granted, sir?
Relief is granted by there to.
Kindly read, sir. Kindly read.
My lord. In this view of the matter, the students cannot be allowed to suffer. It is therefore directed that the results of the students who have already appeared in the examination of first year and second year degree examination 2010, but they were allowed by an order, interim order of the court. So they were permitted to appear in the examination of first and second year degree examination 2010, pursuant to the interim order dated 23rd March 2010 should be declared.
So we are in which year, sir, now?
My lord, that's why I wanted your lordship may pray. I pray for a week's time.
No. How will the week's time answer the question that I'm asking you? Which is the year in which we are now?
But 10 years past, I have no information from the university whether they
Is
were.
there a stay order, sir, in this petition? In this appeal, is there a stay order?
By the order of the court, some order must have been passed by the university. They must have been passed.
Sir, my question is,
And the university has also the power to revoke the order also, to withdraw the degree.
sir, are you able to understand the question I'm asking you? Was any interim order passed by this court in this appeal?
Interim order, my lord. Interim order, I'm reading.
Just show him the paper.
Section 9. No, interim order is not filed.
What is the consequence of that not being any interim order, sir?
Interim order is not filed. Only the last order is filed before my lord.
What is the consequence in a matter like this when there is no interim order? So kindly answer the question. What's his name?
Such interim order.
Just ask him, he's not listening.
Mr. Mahanti, what is the consequence of having no interim order in the present writ petition?
But interim order is there. I'm searching for. I did file the interim order. Well, 23rd March 2010, interim order. That was passed, it was admitted.
Mr. Mohanty, this is the last time I'll ask you this question. In this writ appeal, is there an interim order?
My lord,
In this writ appeal, is there an interim order?
no,
What is the consequence of there not being an interim order in this writ appeal?
writ appeal is filed only on the
All right, I
decision
think
of
we are just
the
wasting our
court.
time. You see,
Not interim
given
order
the
is
nature of the
filed.
matter and considering that there is no interim order passed in the last 11 years of pendency of the writ appeal, the appeal has been obviously rendered infructuous and just disposed of as such. Call out the next matter.
Special list item number 17.
17, 19, 20, 21, certified copy of the impugned orders have not been filed.
For over 11 years now, even the certified copies of the impugned orders have not been filed and defects have not been removed. The appeals are dismissed for non-prosecution.
Item 18,
18.
delay of 692 days.
18, you say the delay is 692 days, it's inordinate and unexplained. The delay is accordingly not condoned. The application is dismissed. Consequently, the appeal is dismissed.
Special list item number 22. Item 22.
None appears to be not.
Special list item number 23.
None appears to be not.
Special list item number 25. 24. 24, sir.
None appears to be not.
Special list item 31.
Item 31, Your Lordship, no instruction in the matter.
All right, no instructions disposed of.
Special list item 32.
None appears this was not prosecution.
Special list item number 33.
But please, Your
May I
Lordship.
please, Your Lordship?
Your Lordship, this is a
I
matter.
am appear on behalf of the workman, man. I am appeared on behalf of the workman, man.
In VC, am I audible, Your Lordship?
Petitioner filed
Yes,
by the
yes,
manager.
Mr. Mishra.
My lord. This is a matter relating to challenging a reference, Your Lordship, with regard to the scope of the adjudication by the National Tribunal created under Section 7A of the ID Act or National Tribunal under Section 7B of the Industrial Disputes Act, Your Lordship.
Yes.
So Your lordship sees the page 18, your lordship, that is the reference, your lordship. Lordship, may I humbly make a prayer, your lordship, simple prayer? Can it be
Yes.
taken up next week, your lordship? I'm a little unwell, your lordship. So that I can prepare a note and also give it.
All right, Mr. Mishra states that he's unwell. List on.
My lord, I
9th
may
May.
provide
9th May.
9th May, your lordship.
Special weekly list item 34.
None of this dismissal. No.
Special weekly list item number 35.
May I please? This is the revisional or so motor revision order passed by the additional district magistrate Bhubaneswar, my lord, under the UGLS Act, my lord. But the lease was granted under the principle of Lease Principle Act 1961, my lord. Therefore, it is takes I pray some time, my lord, for preparation, my lord. Lease was granted under Lease Principle Act in the 1974. After 24 years, that is barred by the Act, my lord.
But recently, your lordship, that question of limitation, my lord, in fact, after 14 years, whether the ADM could have resumed the land or not, my lord, that issue your lordship has adjudicated recently, my lord. And the grounds of writ petition, grounds made a writ petition is identical to the grounds.
The second ground, my lord, the lease was granted under the Lease Principle of 1961, but the resumption, sorry, my lord, the so motor revision order was passed under 7A3 of the OGLS Act. That is also not permissible under law, my lord. Therefore, I trace some time, my lord.
No time, so just carry on with the matter now. What is your case and merits? You tell us that.
My lord.
What is your case on merits?
My lord, the lease was granted by the land Tahsildar in the 1974, my lord.
On what basis?
On the basis of the lessee was a landless person and the income is 3,000 per year for agricultural purposes.
What is the finding in the impugned order?
Well, impugned order is Annexure 1, my lord. Annexure 1 and Annexure 3. First order is Annexure 3. That is running page 24, Annexure 3, my lord. That was quashed and remitted back to the ADM, and the ADM subsequently passed Annexure 1, my lord.
Just come to page 13, sir, 1-3.
1-3, my lord.
Please read from para 1.
Para 1. Additional district wise Bhubaneswar initiated so motor.
So come to page 13, 1-3.
1-3.
Bottom you will have one para 1. That one Adhikari Ojha.
My lord. That Adhikari Ojha being a poor and landless person and being a daily wage laborer having any profitable means of income applied to the Tahsildar Bhubaneswar for sanction of lease of land with respect to a plot number so and so under Khata number 805 of Mauja Andharwa. The Tahsildar settled 500 decimals of land in favor of Adhikari Ojha for agricultural purposes.
Continue reading, sir, if you don't mind.
Then when the Adhikari Ojha, after expiry of 7 years from the date of sanction due to requirement of funds, sold the land to the present petitioner by the registered sale deed bearing number 2948 dated 24/4/1981. Then that original settlee Adhikari Ojha has lost his interest over the scheduled land from the date of execution of registered sale deed, that is 24/4/2081, by transferring the cash land. Such initiation of so motor proceeding against the person who has already lost the interest over the scheduled land much prior to such initiation is not at all sustainable in the eye of law. My lord, I require some time, my lord.
We don't require time.
I have a very good point, my lord.
We don't require time, so you just come to page 15 now.
15, my lord.
Last paragraph.
Land Tahsildar Bhubaneswar, before settlement of the cash land, has not taken any steps to ascertain the annual income of the applicant, along with the family members living with him in common mess. The order sheet as well as the report of the RI is also silent on this report. because annual income beside the ownership of landed property is a vital ingredient to determine the eligibility of the applicant seeking settlement of government wasteland. As per the report of the Revenue Inspector Chandaka Circle, the applicant along with the other family members living in a common mess had an income of 3,000 per annum at the time of settlement of the cash land. The definition of landless agricultural laborer as continued under section 2 bracketed B1 of the OGLS Act 290 provides that person who has no means of livelihood other than the agriculture, provided that he or any member of his family owns no land excluding homestead, and his total annual income together with the total income of all the members of his family who are living with him in common mess from all sources does not exceed 3,600. And the applicant, even having annual income of about 3,000 during 1974, makes him ineligible for settlement of government wasteland. Further, the report of the revenue inspector indicates that they have no land, either agricultural or homestead. Thus, it is not ascertained by Land Tahsildar Bhubaneswar as to whether the applicants are native of village Andharwa or either he or his predecessor has migrated from other area, and if so, whether any landed property is owned at that village. Because while considering the landless of any person, it is to be ascertained from him or her whether he or she, along with his or her family members living in a common mess, own any land property anywhere in the state. My lord, the initiation of a suo motu proceeding is not correct, my lord. As per my observation, initiation of suo motu proceeding, my lord, under the
There's nothing in this, sir. It's covered by this judgment also. We'll pass the detailed one.
Special weekly list item 36.
My lord has been dismissed from service without notice, but he has been convicted under the PC Act.
Counsel, the petitioner states that on account of subsequent events, nothing survives the petition. It's dismissed as such.
Special
I'd like to
weekly
mention, my lord, item 34 permitted to withdraw, my lord.
Special weekly list item number 37.
May I please, my lord? I am on VC, my lord. My lord, the brother of the petitioner, my lord, this is WPCL, my lord. It's a habeas corpus matter. The brother of the
My lord, 37 is something else. Mr. Samantra is there in the 37.
I am for the 37, my lord. I am on virtual mode.
Yes.
But in this case, a small portion of land, which is only adjacent in between the public road as well as my homestead land. It was encroached by the grandfather of the petitioner since 1920, man. It was also reflected in the 1962 ROR under Annex 1. The ROR published in the year 1962, wherein it is categorically said that the Lingaraj Sundaraj, the grandfather of the petitioner, who is in possession still.
So for ROR and all, there are other provisions. We don't have to entertain a writ petition for this ROR.
This is a road, and in the ROR, it is written as Sarva Sadharana road. That is meant for general public. Road cannot be allotted to any private individual.
Right.
And if at all he says that he is in long possession, the remedy is something
That's
else.
what-
He cannot ask for the Tahsildar to allot this land under Section 8A of the OPL Act.
Now it is under the GA department. I have already filed my application before the GA department.
No,
under
question
Annex
of grant of any lease in respect of road land, road ki some land does not arise. That is the specific counter affidavit of the.
There is also a existing road. That is not
That
road.
is a
actually.
different
No,
thing.
but right now it's earmarked for a road.
It is a earmarked road. For in record of right, it is mentioned that Sarva Sadharana road, that is meant for general public. He is an individual. How can we allot the land to an individual which is meant for general public.
Yes.
Yeah, your lordship can see yesterday at the afternoon, they served me a copy of counter.
That's okay, sir. Whether counter or not doesn't matter. You have to make out a case. How can a road be allotted?
There they have also in paragraph 4, my lord, your lordship can see counter they filed yesterday, they served to me. They have paragraph 5, they have already stated the petitioner has to approach the appropriate revenue authority for change in some category of land.
Yes, that is what. Unless the kisam of the land is changed from road to any other purpose,
no
then only we can
kisam
entertain.
Yeah.
So
Right now, the
that
kisam
is
of the land question is
since your lordship
Sarvasadharana road.
I may be pardon, my lord. I will
As
approach
rightly
the-
pointed out by opposite parties, the question of allotting such land in favor of the petitioner at this stage does not arise. Unless the ROR is changed to indicate a different purpose, no such direction can be issued to the opposite parties.
15B, I will apply before the
Petition is
member of
misconceived and is dismissed as such.
your lordship can give the opportunity to allow me to file a revision before 15B.
No.
Under
How
section
can he
15B.
file? What is his local standing?
Right.
Your lordship can see there is a existing road that is not road. I have already constructed 1960 20 miles 100 years back. They are in possession. They are constructed their house, and there is a existing road also. But wrongly it was. I have categorically stated that wrongly it was reflected as a road, but not it is a road. Nobody can use it as a road. That is why for the change of bishop, 15B is applicable. Your lordship can see Board of Revenue member is a appropriate authority to change the kisam of the land after making inquiry. That is why, my lord, your lordship can see that long period the case is pending. Yesterday they have given the counter. Your lordship can give that opportunity to file 15B. There is a revision before the member of the board.
Next item.
Special liquidity item 38.
Give that liberty. Permitted to withdraw or to file revision before 15B.
Item 38.
I am for OP3, my lord. So you
None
are
appears to the petitioner, dismissal, non-prosecution.
Special liquidity list item 39.
This is a case I have challenging the order of termination, dismissal, and also order passed by the Land Tribunal. Right, annexure 10. For the fact is nice, was joined in the service on 17/8/89. After some days, the Sebak and the attendants, they have created all the disturbances in the school, and the authority on 9/3/90 framed charges by the annexure 1 on the ground of moral turpitude and gross misconduct. After receipt of the charges, the petitioner submitted his reply on 9/5/90.
Why does it come before this?
The inquiry officer
matters. Yes.
The inquiry officer has a fixed date to do so 27/8/90 for inquiry. And he sat in his office, which is more than 30 kilometers from the school. And he has.
What is the age of the man, sir?
My lord.
In 2012, you were 62 years old.
Yes. He has dismissal or dismissed. If it is passed by that, he will get some pensionary benefits and service benefits. And in one day, in inquiry, the inquiry officer has taken evidence from 17 persons in his office without calling to the witnesses. The petitioner, he has requested to allow to cross-examine. He has denied to allow cross-examination. And by the annexure 3, the authority, disciplinary authority has passed the punishment order in page 25 without giving the so-called notice, past so-called notice.
What is the charge, sir?
Moral turpitude and misconduct, gross misconduct.
What is it, sir? You have to read out. What was the charge?
page 13. The undersigned proposes to hold an inquiry against Satyanarayana Mishra, head Sevak, in charge, Balyapani Sevasrama under Tumuri Bandha block under Rule 15 of the Orissa Civil Service Classification and Control Rules 1962. The substance of impetus no moral turpitude and gross misconduct in respect of which the inquiry is proposed to be held is set out in the enclosed statement of articles of charges in enclosed as Annexure 1. A list of documents which and the list of witnesses by whom the article charges are proposed by sustained are also enclosed as Annexure 2. Satyanarayana Mishra is directed to submit the written statement.
What is the complaint, sir? You're not telling us clearly.
Charges have not been enclosed, but your lordship may kindly see that can be found out from page 37, paragraph 2.
Misbehavior with girls.
So, more serious allegation. Paragraph 2. And he was the head sevak of the school.
The petitioner in page 15 specifically stated that he, along with the 2 sons and 1 daughter and his wife, are staying in the hostel. The entire family members of the petitioner, they are all staying.
No.
In the hostel.
It's not about just staying in the hostel.
Yes, I have mentioned, my lords.
I mentioned innocent girls will make allegations against the headmaster.
Without any, there is no proof and there is no allegation of the students. The Sebok and the attendant, they have made allegation against the petitioner.
So you have to clearly say what is the allegation. You're not saying that.
As my lord, the Annexure 1 is the charge sheet, memorandum of charges. They have not supplied the others, but I have filed my reply, so called reply via Annexure 2, elaborating everything, my lords.
Sir, if you're not prepared to answer, then we will take it that you have no answer.
No,
Please tell us what are the charges against you.
Charges this, he has given some misbehaving to the class 1, 2, 3 students in the hostel.
So
accordingly,
class 1 is how many years old, sir?
My lord? 7, 8 years old.
So, and what is your age?
My lord? At that time, he was 42 years and total.
So is it serious charge or trivial charge?
It is a serious charge. It is a serious charge. But in his reply, he said, my lords, in page 15, I am a married man having 2 sons and 1 daughter. The eldest son is.
This is a qualification.
My lord?
This is a qualification according to you.
No, that is the marital life he has discussed in reply, my lords. The entire family members are residing in the hostel.
Sir, when you argue a matter like this,
yes,
you must argue with clarity, first of all. Come clean on what is the charge against you.
He is the petitioner has misbehaved to the school children.
That's right. That's right. You want to argue some more on this?
Yes, madam. In the inquiry started on 27/8/90.
What is the kind of defense you are taking? You saw that? The kind of defense you have taken. Have you seen that?
Yes, madam.
Accusing everybody else. According to you, everybody else is wrong. You are the paragon of virtue.
No.
That is your defense.
Because on 17/8/89, he has joined, after transfer, he has joined in that school.
Yes.
After five months,
yes,
the Sebika and the attendant, they have pre-planned and made allegation against the petitioner.
This kind of allegation can easily be made, is it?
They have made, my lords, easily.
I see.
And there is
Come to page 42. How many students have given statements? Come to that. Students give statements so easily, sir.
Yeah,
it's very easy, is it?
Students have
you walk into any school, tell any girl, and she'll give a statement.
The students have not gone to the inquiry officer.
I see.
The school and the inquiry officer office is more than 35 kilometer distance.
All right.
In one day, the inquiry officer has completed his inquiry.
All right.
Not taking any evidence from the students.
Yes.
And the petitioner has requested the inquiry officer to allow me to cross-examine the witnesses. He has denied.
So 5-year-old has to be cross-examined by you.
My lord.
5-year-old girl will be cross-examined by you.
Yes, because they have
I
given
see.
evidence against the petitioner.
I see. All right.
They have given evidence
All right. All right.
against the petitioner.
All right. All right.
And also to the that
This is the whole problem, sir.
Yes.
Your argument, you pitch it like this, you lose whatever little sympathy you want.
No, what
You should know what to argue in which kind of matter. All right.
Yes.
62-year-old man say, I can't insist, I will cross-examine a 5-year-old girl.
No, 62 years after filing of the case and in between the 62. At that time, he was
It's better you leave it like this, otherwise we'll be forced to write more things now.
But as per rules, violating the rules,
yes,
they have completed the inquiry.
What is your stand, sir?
And 1 minute. He has approached to the tribunal. Tribunal remanded the matter to the authority, disciplinary authority, but by following the OCSCC rules 29 to pass the order. Thereafter, without following the same, without hearing, again passed the same order, confirmed the order. Against that order, I have moved before the tribunal. Tribunal has dismissed my appeal on the ground of limitation. The specific without I have filed also limitation petition and medical certificate. On that ground, it was dismissed.
Correct. 3 years later, you have gone. Come to page 40.
Yes, that is.
Your argument should be much easier now. Para 5, page 40.
Para 5. We have perused the documents in the way along with the enclosures. The applicant has challenged the order dated 99. In a way, this tribunal, in order to order that had already observed that the OA is barred by limitation of time. At that time, he was under treatment in the Raurkela, and he is taken the after certificate from a doctor and filed the case after two years. Therefore, there is a delay. I have also mentioned in that limitation petition, that is page 32.
Yeah.
Condemnation of delay.
Yeah.
And the appellate authority, without following the rule 29 of OCSS, will pass the order. And the disciplinary authority, without issuing the second cause, so cause notice as per the OCSS rule 16.4, he had passed that order.
Challenge the present petition.
Which is mandatory in nature.
Is to an order dated 24th February 2011 passed by the Orissa Administrative Tribunal Bhubaneswar, dismissing OA number 2041 of 2002 filed by the petitioner on the ground of limitation. The operative portion of the injunction order reads as under. Paras 5 and 6. Paragraph learned counsel for the petitioner repeated the argument that the petitioner was suffering from depression and therefore could not file the petition before the OAT in time. The documents placed on record with the petitioner in support of such plea was not found to be convincing by the OAT. This court is unable to take a different view in the matter, with there being no proper explanation for the inordinate delay in approaching the OAT. There is every justification in dismissing the application on the ground of laches. Consequently, the court is not inclined to interfere with the issued order. It is dismissed.
Special legal list item number 40.
My lord, I am appearing for the petitioner. The matter becomes infructuous.
Counsel for the petitioner states the matter has been rendered infructuous. It is disposed of as such.
Special legal list for orders item number 41.
Yeah. All right. The last line be corrected as indicated. Yes. Same.
This list is over. 41, 42, and 43.
Same.
This is over. Weekly list. Fresh admission item number 1.
May I please, your lords?
Lordship, as per my lord's order dated 12th April 2022, this writ petition along with 7953 of 2022, my lords, list on 27th April 2022.
All right, yes, done, sir.
Weekly list for orders item number 2.
None of this is not.
Weekly list item number 3.
This is relating to the registry, my lords. A new proposal is now pending before the government. So they need to take instructions probably on that.
Lords, may give some time. I'll take instruction regarding that rule, and also another letter I have received. I also take instruction regarding that filling of the rest posts.
All right. Yes, actually, there are some discussions on.
Yes.
Okay. You see, list on, simply say list on. 1st August. All right.
Weekly list item number 4. Weekly list item number 5. Weekly list item 5.
None of this is not.
Weekly list item number 6.
My lord, may I plead, my lord? My lord, in this case, I may be permitted to amend my writ petition only to insert the GA department, my lord, as a opposite party, my lord.
All right. Defects be removed
by tomorrow.
I have already settled the issue involved in this present batch of writ petitions is Ignacius Ray's case.
Sorry?
Regarding the Ignacius Ray's case regarding applicability of the rehabilitation assistance rule.
I know, but there is a subsequent judgment of the Supreme Court, sir.
But
which
that
takes a different view.
That has not taken note of that NC Santosh decision.
No. Subsequent judgment of the Supreme Court.
Yes. Supreme Court, NC Santosh has not been taken care of.
I know, but what to do? There is a judgment of the Supreme Court.
Let them solve a copy because they have not solved
Yes.
it.
Defects be removed within a week.
I have already solved, my lord. Solved the extra copy.
You have to serve. Remove all the defects.
My lord, I may be permitted to amend this writ petition by inserting GA department as
You have to move an application anyway, sir.
Yes.
You have moved an application for that.
Yes, my lord. I have filed, my lord.
All right. These 2 IAs are allowed.
In every
Wait for
case.
the amended cost title be filed within a week. Defects be removed before in the same time. List thereafter.
All the cases same.
All right.
Always.
Weekly list item number 7.
7, may I please your lordship? On 4/1/2022, your lordship directed to list this case after removal of defect. In the meantime, I remove all the defects. And by wrong noting is there, that defect is there. I have remove all the defects in the meanwhile, my lord.
You have to convince the registry, sir. Defects be removed within week list thereafter.
Already remove, my lord.
So they're still pointing out, sir, 3 defects.
Now that defect is on the earlier occasion also, the same defect were pointed out. But
Copy has not been solved. So defect number 6 relating to solving a copy to the State Council.
Copy I have already served, my lord. I have the Xerox copy and original copy I have at the time of removal of defect. I have already enclosed in the matter, my lord. I have already served the copy, my lord. The only prayer in this case is Annexure 2 is pending before opposite part number 4.
All right. You say the written complaint dated 9th September 2021 be examined by Collector Cuttack, and after giving the petitioner a hearing, a reasoned order should be passed thereon not later than 4 July 2022. The order shall be made available to the petitioner not later than 11th. The court clarifies that it has not expressed any to the matter. All right.
Obliging. OP number 4 then.
Weekly list item number 8. Item number 8.
Am I audible, Millard?
Yes.
Millard, in this PIL, this is a very small matter, Millard. The petitioners are the
A lot
residents.
of defects. You have to remove the defects, sir.
Millard, almost all the defects have removed.
Whatever is remaining, you remove. Defects we removed within a week. List thereafter.
Weekly list item number 9.
Yes, my lord, in item number 9.
Withdrawal memo is taken on record. Dismiss as withdrawn as paid for. All right, sir.
Weekly list item number 10.
Better application. With the leave to file a better application.
In terms of the memo filed, sir. Withdrawn. Dismiss as withdrawn in terms of the bill. Yes.
Weekly list item number 10.
May I please, madam? And no, only grievance of the villagers to pending before opposite member 3, my lord. The opposite member 6 and 7 unauthorizedly lifting sand from the river and use the Pradhan Mantri Grama Sadak, my lord. Protect the interest of the villagers, my lord.
No, but what is that to show? You have served this petition on the other side.
My lord.
The stamp for page 10, the collector stamp.
Okay. Grievance petition pending before collector, my lord.
The written
For
representation. Bracket annexure 2 be examined.
Page 10 annexure 2.
The collector then cannot. And after issuing notice to the petitioners as well as opposite parties 6 and 7. And after giving them a hearing, a fresh order shall be passed. A reasoned order shall be passed not later than 4 July 2022. Copy of the order may be made available not later than 11th. Court clarifies it is not expressed in the matter.
Weekly list item number 11.
I mean, pardon me, Lord. Item number 4. Unfortunately, I was in court number 2 minutes, so that's why I could not able to come before my election. Item number 4 week list.
We wait, sir. Let the list be open. Yes. We are now in the midst of something else.
Item 11.
May it please, Mulats. Mulats, 2 defects have been pointed out by the registry.
Few of them, sir. List after removal of defects.
Mulats.
All right.
Weekly list item 12.
Thus, may kindly turn to Annexure 3, page 13. The assessment was reopened by the jurisdictional officer. Thereafter, it was transferred to the National Festless Assessment Center. My lords, Lordship will kindly see.
JCIT, joint CIT.
Huh?
Satisfaction of joint CIT, sir.
Yes. Joint CIT.
On that short ground test to go.
Let me take instruction because.
No, joint CIT, sir.
Not 4 years.
No. Joint CIT.
Joint
that
CIT.
ground it goes.
20 is it 16, 17 assessment here?
31st March, sir.
31st.
And the sanction is from the joint CIT, not the CIT. On the short ground that the impugn notice has been issued with the satisfaction of the joint CIT. Impugn notice dated 31st March 2021 under section 148 of Income Tax Act 1961 has been issued after obtaining the satisfaction of the joint CIT, range 1 and not the CIT. The impugn notice is hereby quashed. The petition is disposed of.
Consequently, the order of assessment on the Annexure 1 and
Yeah. Consequent orders of assessment and any further orders are hereby quashed. All right.
public.
Weekly list for admission item number 13.
Item 13 permitted to withdraw.
Council
I have filed a memo.
seeks leave to withdraw the present petition. Dismiss as withdraw. All right.
Appearance of
All right, sir.
Weekly list item 14.
Yes, to my lord's direction, they have paid the amount, but they have served me copy a day late, my lord.
That's all right. What is it now?
Now they say the property that they had declared in 2005 is not mortgaged and given an affidavit on the basis of which it was released in my favor. Now they say I had executed a document, my lord, mortgaging the same for which they have initiated criminal proceedings.
So,
your lordship may visualize and see that order, your lordship, on the basis of that affidavit.
Where is Mr. Das? Last time Mr. Das appeared, Samitav Das.
Was appearing for corporation, my lord.
Where is he? We'll pass it over.
I'm for OP number 5.
Option. We'll just pass it over once.
Weekly list item number 15.
But item number 15, with your lordship permission, I may be allowed to appear on VC. But after the petitioner, in this case, I was trying to contact the petitioner, and somehow I got to know that the writ petition, the subject matter still survives because the shop room which is disputed is been protected by the order passed by this honorable court.
You say the subject matter has been rendered infructuous by subsequent developments.
My lord, it still survives, my lord. That is what my submission is. On the last occasion, your lordship was of the view that whether the subject matter of dispute still survives. My instruction is still survives because of the protection granted by the honorable court, my lord.
Okay, you argue the matter.
My lord, here, my lord, annexure, your lordship looks at annexure 6, annexure 8, my lord, page 46 is under challenge, my lord.
Yes.
This is an appeal filed under section 24 of the Jagannath Temple Act. The appeal has been preferred by the private opposite party, my lord. If your lordship permits, may I submit the brief facts of the case, my lord. Here, my lord, the petitioner's husband, one Madhusudan Das, was granted with a license by the opposite party number 2, my lord. Pursuant to the license, he was running the shop in Ananda Bazar in Jagannath Temple. Thereafter, he died. The present petitioner's mother, Jema Dei, became the license holder. Thereafter, the said Jema Dei entrusted the shop room to the private opposite party in the present writ petition because she personally could not run the shop room. Thereafter, the private opposite party took advantage and misutilized the shop room. Therefore, Jema Dei asked him not to, my lord, run the shop room. Taking advantage of the situation, my lord, the said private opposite party filed a writ petition when challenging an order of eviction, without disclosing the fact that he is no way the owner of the shop room. In the said writ petition, he never disclosed about the fact that Jema Dei is actually the successor. In the said writ petition, this honorable court passed an order that the shop room is to be handed over to the petitioner. However, the said Jema Dei was granted liberty to dispute and raise a claim so far as her right is concerned. Thereafter, said Jema Dei filed a petition before the opposite party number 3, stating that she is the actual successor after the death of her husband and not the present private opposite party. The said claim petition was allowed, holding that yes, Jema Dei is the successor, my lord, not the private opposite party. That order, my lord, was challenged in an appeal filed under section 24 of the Act, and the same appeal has been allowed, which is the subject matter of dispute. My lord, my ground of challenge to that order is that so far as the issue that whether Jema Dei is the successor or the private opposite party is the successor, though that was declared in favor of the petitioner, but without assigning any reason, not even having a discussion on the same, the appeal was allowed. If your lordship looks at page number 53,
yes, please.
or went approached the civil court, my lord, for a declaration. Interesting fact is, my lord, they have filed a counter affidavit in the present writ petition. Counter affidavit on
Who's for the other side?
Lord, I am for the state, but.
But
the
opposite party number 4?
Private opposite parties.
Archat Rana Das.
My lord, what I find from the appeal memo at page 42, my lord, Mr. Patnaik can also see that he has disputed that Jema Dai is not the wife of the original lessee. That is why the issue regarding succession, and he left it open for the civil court to decide that. There is a dispute with regard to the status of the petitioner as the wife of the original lessee in the appeal memo. Your lordship may kindly see page 42, ground number 19. As there was a dispute with regard to the status of the petitioner being the successor of the original lessee or wife of the original lessee. That is why perhaps the impugned order, the administrator has left it open to be decided by the appropriate court of law.
Correct. My lord, may I, with your lordship permission, may I rebut, my lord? My lord, in the counter affidavit at page number 2, your lordship will find counter affidavit filed by opposite party number 4, Archat Rana Das, my lord. He states that this present petitioner, Jema Dei, is actually the wife of another Madhusudan Das who states in another village.
Exactly.
All this can't be examined in a petition, please.
Absolutely, my lord.
Dispute with regard to the status of the petitioner as the wife of the
lessee. Highly contested. It's better to go to the civil court.
That is why the matter was referred to the Supreme.
Matter was referred to the civil court if the dispute is only with regard to succession. My point is, my lord, the original.
No, but anyway, these issues can't be thrashed out in a writ petition, please. It's all highly contested.
My lord, in the appeal order, my lord, that was never discussed. Therefore, the order passed by the learned opposite party number 2, challenging which the appeal was filed, there he has simply said that the license was with Madhusudan Das. After his death, it is to go to the wife, my lord. That order holds good, my lord. And perhaps, my lord, after everything was passed by this honorable court, the appeal memo was filed wherein he has raised a dispute. Until then, my lord, he suppressed everything before and approached this honorable court. He never states that he is the owner. And my lord, another legal aspect, if I may be permitted to, my lord, raise, my lord, Section 24 of the Act came into force in 2004, December 27, December 2004. The appeal was filed in August 2004. Therefore, the appeal itself is not maintainable. Section 24, Orissa Amendment came in 27/12/2004. Appeal was filed in August. So far as the maintainability of the appeal is concerned, also, I have raised that ground in my report.
Since you've been relegated to the civil court, we don't see any prejudice being caused to you.
In fact, they have given an order and they have not simply relegated, they have passed an order. Your lordship looks at page 56, they themselves say that it is to be adjudicated by the civil court, but the possession of the shop room number 10 is to be handed over to the private opposite parties. The order was passed in my favor.
Whether the order has been carried out or not, that is also to be seen. Because in the meanwhile, 16 years passed.
And I was protected by this honorable court.
So there is a status order.
Yes.
No, but what is the prejudice? We're still not clear. What is the prejudice caused?
Prejudice is, my lord, I was holding the shop room. He approached this honorable court by suppressing the fact that I am the wife or I am not the wife. That was never raised. He says that I am the license holder, which he never was. The license holder was Madhusudan Das. Suppressing the everything.
No, what is the prejudice by the remand?
They have not remanded. If your lordship looks, they have not remanded.
Remanded meaning civil court.
Yes,
civil court. They have not
relegated to civil court.
They have not relegated. They have said that you hand over the possession to the private opposite party. And if there is any dispute, that is to be divided by the civil court.
Yes.
what they could have, my lord, with all due respect, my lord, humble submission is, what they could have done is, if it is to be decided by the learned civil court, they should have simply said that it is to be decided by the learned civil court, and that declaration would hold good, my lord. They have adjudicated, passed an order against me, and then made an observation that it is to be decided by the civil court.
My lord, in any case, the shop has to be carried out by somebody. Her status is in dispute.
Got a stay for last 16 years, sir.
It is, that is what I am also astonished, because it is a shop inside the Anand Bazar, very sensitive place. And this man, opposite party number 5, he was operating the shop on behalf of the original lessee. He was in possession. That is why I say that even if there is a status quo order, whether he is still operating the shop or not, that is to be the administration.
Who's for opposite party number 4?
Mr. Satpathy is there, but he is not there.
Counsel, the petitioner at the outset states that the interim order, pursuant to the interim order passed by this court on 16th May 2006, directing status quo to be maintained in respect of shop number 10 inside Anand Bazar of Sri Jagannath Temple, Puri. Status quo continues. Paragraph. It is seen that before the appeal subcommittee, the main contesting parties were the petitioner here and opposite party number 4. However, opposite party number 4 does not appear to have, does not appear today.
And he is the son of Madhusudan Das. He is the son of Madhusudan Das. He is claiming that, kindly see the cost title, my lord, Arthatrana Das, son of Madhusudan Das.
Anyway, we'll have to hear him.
Yes.
Fresh notice will be issued now to opposite party number 4. Requisites be filed. Returnable by speed post on 15th May, 15 May. Interim order to cut.
Weekly list item number 16.
Kindly pardon me, my lords. May I mention one matter, my lords? Orders item number 2, my lords.
Not in the between, sir. We'll finish the list and then you mention.
Must take it up.
At the end of the list, you mentioned what was
Item 16.
May it please your lordships. My lords may be pleased to see space 16, the order sheet which I have. Item number, my lords, 5085. I'm sorry, my lords.
Yes, 5085.
Second item. Yes.
5085.
Kanakadhara Mini.
Kanakadhara Mini. Sorry, my lords. You will kindly see, I have enclosed the order sheet, which is annexer 2. It starts from page 14. Page 16, lords, you will kindly see the audit report was submitted after it was completed on 23rd of March 2013. Then it was submitted on 2/8/2013.
This is not before the full bench?
This was the full bench. This was, yes. And where your lordship said that the referral bench was bound by the earlier bench, since they did not frame the questions. And I have got the order of the to be done in that way or in not at all. And your lordship will kindly see how the opposite parties have interpreted page 4 of the counter affidavit, para 10, sorry, page 4 in column wise, they have given a date-wise reply.
Your Lordship.
May I, let me complete.
I'm in your favor.
Your favor.
Your Lordship.
Online.
Your
First
Lordship,
time
this honorable court has passed the order in case of Jindal, Your Lordship.
Yes.
So it is coordinate bench has passed, and this order, unfortunately, that order has not been challenged before any higher forum, Your Lordship. So that is judgment is binding so far as that 7 days, 41-4, 7 days is concerned. But some other portion is there, and I'll argue those parts in the second cases. So far as the cases of my Lord and Senior, these are covered. 7 days, admittedly, in my counter also at page 4 and page 5, it has been admitted that it has not been submitted to particularly to the assessing officer. It has been submitted to the range, and subsequently range has distributed the file amongst the assessing officer. So particularly so far as that language is concerned to the assessing officers, that 41-4, that it is admitted that has not been submitted within 41-4, within 7 days. From completion of the audit visit report. Why I'm giving emphasis, because I will argue in other cases so far as this aspect is concerned.
So Mr. Roy's cases we can allow them.
Your Lordship.
Which are the writ petitions, sir?
Sir, 50, my lords, I'm sorry, my lords, 5085 of 2014.
87.
This relates to the period 7-8 under the CST Act, and the other one is 5085 CST.
Your Lordship, one more argument, Your Lordship. So far as the Jindal case, 41-4, Your Lordship. For so far as the
let us now deal with Mr. Roy's matters.
Yes.
See, in all these three matters or two?
Two.
So far as period 5087, that is under the VAT Act, and for the period it is the same 7-8, 1/4/2007 to 31st of March 2008, same. So common order
5085 and 5087.
Yes.
Right. 5085 and 5087.
First one relates to CST Act. Second one, that is 5087, relates to VAT Act.
All right. The admitted position is that the audit report was not sent directly to the assessing officer. Right?
Your Lordship, to the assessing officer. Directly, it cannot be, because in the range, Your Lordship, there is a segregation. There is a range and there is circle officers. And assessing officers, in the range before the just below assistant commissioner, there's sales tax officer, different assessing officers.
Those things are not there.
So
in this
audit officer cannot ascertain that who will be the assessing officer. So thereby, the file has been, the audit report every year is to be submitted to the range authority. And then
it's admitted that the audit of our report is not submitted to the range authority.
Assessing officer.
Assessing
officer. The provision says that
that's what I've dictated, but you're interrupting.
I'm sorry, I could not follow. I'm sorry.
Not submitted to the assessing officer, and that this is contrary to section 41(4).
Yes.
Of the OVAT Act,
2004.
Right. On that short ground, the impugned assessments based on such audit report is hereby set aside. These petitions are disposed of. And the consequential demands are hereby
consequential demand.
Your Lordship may put the language after completion of the audit. After completion of the audit within 7 days. Because the
within
provision
7 days after completion of the audit to the assessing officer. All right.
Your Lordship.
Your Lordships, I may.
My Lord,
Your Lordships, I may be permitted to.
This is in WP Civil 5085. In 5087, it is a CST Act.
Yes, ma'am. That VAT Act. First one is CST Act. Second one is.
Okay, so this order which I've dictated is in 5087. 5085, you say.
Is under the CST Act.
This is an assessment. The challenge is to an assessment order under the CST Act.
Man.
For the period is that
7-8.
The audit report on the basis of which the assessment was made was not submitted to the assessing officer within 7 days of completion of the audit. That view of the matter, the impugned assessment and the demand are hereby.
Under Annexer 1(1)(a), my lords, in both the cases.
Right.
My lord, the first item, the same issue, my lord, same issue involved, and the kindly have a glance to the order of this honorable court 20 October 2014, my lord.
Your Lordship, so far as the first matter is concerned, I may not, it is admittedly, it has been submitted within 7 days. Because the AVR, the offer side of AVR says the signature, initial, everything. But here the assessing officer himself has written in the order of assessment that it has been belatedly, it has been received. Your Lordship may kindly look into the Annex 1, page 7. At the top, the initial, the AVR, the initial is there, CTO BH1, signature is there 6/9/2008. The date is there. And admittedly on 6/9/2008, the AVR has been completed. On the same day, it has been submitted to the assessing officer. But unfortunately, your Lordship may kindly look into page 19, the assessment order. Second paragraph. The audit visit report in case of the instant dealer for the tax period so and so has been received from the STO audit unit Bhubaneswar range by the assessing authority on dated 16/10/2008. This is more than 7 days.
Correct.
So it, as your Lordship pleases.
Yes. Although it's pointed out that although in the form VAT 303, the date of receipt of the audit report has been indicated as 6/9/2008. In the impugned assessment order, the date is indicated as 16/10/2008, which is clearly beyond 7 days after completion of the audit. And therefore, the mandatory requirement of section 41(4) of the OVAT Act 2004 is not complied with. Paragraph on the above ground, the impugned assessment order and any consequential demand are hereby quashed. This repetition is allowed. What were the remaining repetitions?
No,
Your Lordships in sub item 4. Your Lordships, Mr. Shashwat Kumar Acharya. 8484 of 15, Your Lordships.
Yes.
Sir, in this case, Mr. Shashwat Kumar Acharya is appearing and he is on his legs before another court. So this matter may kindly be passed over, Your Lordship.
What about the fourth matter?
This case, it has been complied with. He has admitted in his read petition, pleadings itself.
Oh.
In both the cases, in both the last cases, in the pleadings in the read petition, it has been admitted that it has been submitted within a period of 7 days.
Then what's the ground of challenge then? Then let it come.
Yes, Your Lordship, this may be passed over.
Can have it on some other day. Just say 8484 and 19127. 2016. The petitioner is in some difficulty. List on 19 July.
Oblige, Your Lordship.
Weekly list item number 17.
Your Lordship, item number 17, on the last occasion, Your Lordship has directed me to file affidavit in order to controvert that whether the NALCO has received the refund of 29 lakhs or Your Lordship. Your Lordship, actually, in the meantime, there are 3 offices, Bhubaneswar, Angul, Dhenkanal. Your Lordship, it is so old file, Your Lordship. Already I have instructed and I have issued the letter and they have given the reply, Your Lordship. Only 15 days time may be granted as a last chance, Your Lordship.
All right. Counsel for the opposite party prays for and is granted as a last chance. 4 weeks time to file a reply. Rejoinder will be filed for the next day. So NALCO has filed.
Your Lordship, NALCO has filed counter.
You are for 2 and 3.
NALCO has stated, Your Lordship, what is the issue here is that.
No, I'm just saying, whom are you for?
I am for the Commercial Tax Department.
Department, you say. Okay.
No, I'm for the opposite party, Your Lordship.
As a last chance, the counter will be filed on behalf of the department. Not later than opening day, 20th June. 2020. 20th June, 20.
Your Lordship, grateful, Your Lordship.
Rejoinder will be filed for the next date, list on 28th June.
Weekly list item number 18.
May I please, Your Lordship? I am through virtual mode, Your Lordship.
Yes.
But here, Annex 6 at page 132. This order was challenged for reasonable court in this writ petition. But the Planet Commissioner for Person with Disabilities Orissa had issued a direction for making reservation, horizontal reservation in respect of disability persons in the advertisement. In fact, initially when the notice was issued, we filed reply. And this order of the Planet Commissioner was stayed by reasonable court by the order dated 28/9/2012. And it was also directed prior to that on 24/9/2012 that the advertisement shall be subject to the result of the writ petition. Now, my lord, what has happened? My lord, in fact, we have read reservation with regard to disability persons in terms of the mandate of section 33 of the Act.
1 minute, who's for the other side? And replies hadn't seemed to have been filed, Mr. Mishra.
My lord?
Was any reply filed here?
My lord, Your Lordship may pardon me since I received the brief on transfer. As far as my brief is concerned, my lord, no reply is there. And there is no noting to that effect also in the list also.
Actually, a notice has been issued way back on September 2012.
But I beg to clarify one more thing, I think, which will solve the issue. Your Lordship will only permit me 2 more lines. In fact, if Your Lordship will see the advertisement, as per the direction, though I have questioned the authority of the Land Commissioner to issue such kind of direction and stay the advertisement, which has been resolved in the interim order by granting me a stay by this noble court, fact remains, in reality, horizontal reservation up to 3% as mandated under the statute, section 33, has been made in this case, which will be apparent not only from the advertisement, but also written note was filed for the Land Commissioner saying that we are following that. And despite that, a direction to stay the advertisement and also this final direction under Annex 6 was issued, and that is why this noble court was, the petitioner moved this noble court. And in fact, pursuant to the interim order passed by this noble court, the
point is, despite more than 10 years, no reply seems to have been filed.
My lord.
Correct? No paravase reply despite more than 12 years of notice. Who is the main contesting party?
In fact, the Land Commissioner for persons with disability has been made the opposite party, no other party has been made. But here the state government will have a say. In the sense, in terms of the directive of the state government, which I have annexed, we have made reservations. Also, person with disability, we have made 3% reservations in terms of section 33, Your Lordship. And that is also on horizontal basis. As per the impugned order, the Land Commissioner has said,
let us make the commissioner a party. Correct?
Our institute, the office has reported that copy has not been registered by the.
Actually, Mr. Mishra, Commissioner for Disabilities is the only opposite party.
Here, the only opposite party, because directive was by the Commissioner, Land Commissioner, no other person was responsible. But the state government may be a proper party, if not necessary party.
All right. Having heard counsel of the parties, the court is of the view that the government of Orissa should be a necessary and proper party to the present petition, and is therefore arraigned as opposite party number 2. The consolidated cost title be filed within a week. Notice. Do you take notice for government of Orissa, Mr. Mudlik?
Yes.
Yeah. Notice will now issue to the Commissioner for Persons with Disabilities, Orissa, Bhubaneswar.
Copy be served. Copy of the writ petition be served.
Yeah. Copy of it. Returnable. 6th July.
And the interim order was there, may kindly be extended because the has
correct. Interim order.
Much obliged, man.
Yeah, unhappy with
yes, madam, I'm unhappy because
then you have to challenge it.
Because yes, madam, it is the list is pending before your lordships. Now the mood issue to be decided by your lordships is: can the licensing authority under the Urban Police Act expunge the statute? That is section 444.
If you have to challenge the regulation, you challenge it, sir.
I am not challenging. It is to be incorporated in my repentation. It was there. The DG had, the Home Department had sent into the DG, but it was not considered, and they have notified it.
The list is pending before your lordship. During pendency, they have done this, my lord.
So what?
So
What is wrong in doing it while spending? It's good only.
that your lordship has
that-
directed us to give the status
Yes.
report and we have given the status.
Yes. No, if you want to challenge it, you challenge it.
I don't want to challenge it
Ah.
because the list is pending before my lord.
No,
and it
you're
is
not
to be
understanding.
interpreted.
I don't know what kind of argument this is, Mr. Monty. Suppose a writ petition is pending, some statute comes in, some rule comes in. You say, no, I don't want to challenge the rule because the writ petition is pending. I don't understand what that means. Then we simply say the regulations have come in, we have nothing more to say and we dispose of the petition.
But it is against the general rules is against the statute.
Unless
my
you
lord.
say that, unless you file an application or amend your writ petition to
It is
say
it
that,
is in my rejoinder, my lord.
can't be by a rejoinder,
There has to be
sir.
a prayer to that effect. You can file this.
Because
There is no rejoinder.
yes, here I am holding, my lord. Today I am filing.
That is.
Today I am filing, my lord. Sorry.
File an application, not like that. Anyway, file an application to amend the writ petition to challenge the regulation. Mr. Monty states that he's agreed by the regulations. That is the Bhubaneswar Cuttack Police Commissionerate bracket registration of private residential hostels for educational institutions bracket regulations 2016. Is permitted to file an application to amend the writ petition for that purpose. List on. We'll keep it in July. Your application will come up earlier, 25th July.
Obliged, my lord. Obliged.
All right.
Weekly list item 22.
None appears. to
Madam,
say.
next week, Mr. Patraji.
Yes. Yes.
Weekly list item 23.
May it please your lordship.
In this case, I have filed a time petition to give some time for filing of the counter affidavit. 2 weeks time maybe.
All right. 2754 of 2022 for the reason stated, the application is allowed. Time for filing the reply is extended by 4 weeks from today.
Your lordship may grant 2 weeks. Your lordship, if the new policy is announced, then this matter may become infructuous.
2 weeks time maybe.
All right. 2 weeks. All right. Rejoinder for the next date. It's on 16th May.
Obliged, your lordship.
16th May.
Yes.
Weekly list item 24.
Review petition.
24. Yes, my lord. This is that Mr. Rao has been served with that notice, that review petition I have filed to expose that status code. Lordship, on last date, Mr. Rao was not present and your lordship has directed the registry to serve copy on Mr. Rao.
Was it served? Serving Mr. Rao is supposed to be AD. That AD has not come back.
He is in court. We can.
You serve it on him.
May I pray one thing to Lordship? Lordship may indicate the name of Mr. Rao in the cause
Mr.
list. That is why he is
Rao's
not.
name be indicated in the cause list. An additional copy be
Mr.
served
SS.
dusty on him for the next date. List on 4th May.
Weekly list item 25.
May I please know? This is a PIL, my lord, challenging the manner in which the public hearing was made in respect of mines operation in Koraput, my lord, in Mali Parbat. The people were prevented, my lord, from reaching this spot. Heavy police force was deployed, and last time lordship directed the government of India to file that counter. They have not filed, but the opposite party number 1 and 2, 3, 4, and 8, they have filed the counter. I have prepared the rejoinder, my lord, and 582 people, affected people, they have shown their affidavits, which is a part of my rejoinder, my lord. I am serving a copy. Today, my lord, I am filing the rejoinder.
All right. Mr.
And-
Jena says that he will
Same may
The
be
filing
other-
is rejoined during the course of the day with copies being
my lord,
served on other parties.
May I say, my lord, this affidavit was shown by one of our scientists on behalf of secretary. He made authorized to file. That's why we file affidavit, not a counter affidavit. If lordship accept it, it's authorized. I will insist the concern.
No, where is that? Where is the
My
affidavit?
lord, I'm appearing along with learned Asia.
So you file it.
My lord, I have only one copy. I'll serve one of
All
them.
right.
In the course of the day, my lord.
Mr. Pari states that the affidavit of
one of the scientists has filed.
OP number 6, man.
OP number on behalf of
also be filed during the course of the day.
the affidavit, not by the ministry.
No. The party is only the ministry, sir.
Yes, that's why it cannot be filed. Let's may give some time. The ministry will file.
All right. Mr. Pari prays for and is granted 2 weeks' time to file a reply on behalf of opposite party number 6. Rejoinder there to be filed for the next date.
Okay.
Interim order to continue. List on 11 July.
Oblige, man.
Weekly list passed on matter item number 14.
Item number 2, my lords, I mentioned.
Weekly list, old weekly list, item number 2, my lords.
Yeah, same.
Item number 2, I want to press this application.
Yes.
Old weekly,
my lord. Today weekly list, old matters, item number 2.
Just give us a matter number, sir.
WPC 6761 of 2004.
We are right now in this weekly list. We'll finish this and we'll come to that, sir.
Item 4.
Well, after lunch?
We don't know, sir. You just have to wait. Kindly be patient. Whenever we are finished with this list, we will take it up. We've already come to the end of the weekly list. You will have to wait, sir.
Mine is item HO 34 of 2000.
Yes.
There, I filed the respondent number 1, private respondent, who is the main contestant. He passed away. She passed away. I filed 3 petitions, kind of glance to order 21 rule 4 CPC for substitution, setting aside abatement and limitation.
All that is allowed. Yes. Tell us what the matter is about now.
Matter, this is relating to age. This is an HO. I am to prepare a detailed date chart because fact remains, the council who was conducting the case
That's
died
all
of
right. We're
cancer.
not adjourning, so it's 22 years old.
I don't pray, I pray only for tomorrow.
No. We'll otherwise reserve orders. You file your name.
No, may I submit one thing? Because this is an HO matter. No, this is a reversing judgment. Pray after lunch. So that I will prepare and argue. I'm ready
you prepare your notes. We'll reserve orders. You prepare your note and file your note of arguments.
It may not suffice to give the detailed particulars because it involves very huge property of the government, which has been given to the housing board.
Yes.
And the housing board has in part of that has been allotted.
Yes.
But the decree, there was an ex parte decree in another suit against which the suit was filed.
It's a 2000 matters, sir.
Everything has been dealt with.
And already a written note is already there.
No, written note is there. Fact remains, kind of visualize my position. The council was conducting the case, died of cancer.
Yes.
The second council died.
Yes.
Then I have to put into the position.
Whatever.
So
there you can't wait till the last minute to tell you now. I'll go and appear.
I am not on their matters because that is what I am submitting matters to the fact. If I should put it up tomorrow, I can appraise matters all the details. If I should put it up tomorrow,
No. Is there an interim order here?
So this is an HO matter,
I'm asking if it's an interim. There is an interim order, sir. Of course, we know it's an HO.
Interim order.
There is no interim order.
Management put it up after launch. I'll come prepare.
It's all right.
Because fact remains, 7 acres, some odd properties which has given to the housing board, it is being taken away. That is what the suit, and we succeeded in the suit. It was reversed in the first appeal, against which we preferred HO. And a part of the project.
No, I think initially it was dismissed. You went to the Supreme Court. It's come back.
No, that was remanded. Thereafter also it was dismissed because the council could not appear because he died in the middle.
So there has never been any interim order, sir.
No, that was their matters. But fact remains matters.
It's okay. We can reserve orders. You pass your note, file your written note of arguments. So orders reserved. It will be open to the council with the parties to file their respective written notes.
May I submit matters? Only few lines I will submit matters if matters permit me. A written note of argument I will submit matters. It's my duty. I am to submit matters.
I don't have, it's my duty to submit, my lord.
Yes.
I'll take 2-3 days time to prepare a detailed written note of submission and submit it.
Yes.
But my lord, if I will submit something, my lord, verbally, my lord, it can appraise, my lord. So I can appraise what is my problem, my lord.
Yes.
It's a government who has given the property to the board. The board has developed a portion of the property, my lord, a scheme and allotted to the different allottees. In the meanwhile, by virtue of the expiry decree, they wanted to take away the property of the government on the basis of Hathfota. And that against that we preferred the suit and we succeeded in the suit. Thereafter, the opposite part number 1 who died, he preferred the appeal. She preferred the appeal. In appeal, it was reversed by the Honorable High Court. Against which this HO appeal on technical grounds. I will appraise about these technical grounds and my contention in this.
No technical ground. Everything has been dealt
What is
with.
my submission? Is my
Everything has
friend
been
is
dealt
there?
with. Everything has been dealt with. All the
No, I have gone through this. I have gone through there. The only thing is that, my lord, that has been dealt with on technical ground. What about 80 CPC notice? Whether 80 CPC notice, serving a 80 CPC notice would waive out the condition that the necessary party should not be implemented by party and would be bound by that decree.
Exactly that.
Well, that is the thing, my lords. I will appraise all these things, my lords, with reference to the judgment and all these things. Then, my lords, I will file also a written note of submission for my lords' consideration.
Do that, sir. Just file the written note of submission. Orders reserved, written note of arguments be filed by both parties within a week. Right.
Pastor note
Filing
by
by
25th. Written note by 25th.
1 week.
One. Obliged.
Item number 4.
Item 4.
I had in court number 2. I had gone in court number 2. Unfortunately, I could not appear.
Tell us what the matter is.
But that is the public interest litigation, my lord.
Yes.
And that is 200 persons they were displaced.
No, you didn't file requisites for last 6 years, sir.
My lord, requisites, my lord, I had already filed the requisites, but last
correct address is not given, sir.
Within 3 days, my lord,
for the last 6 years, the requisites of admission notice
To
for service
height.
on opposite party number 5 with the present correct address has not been filed. The court is not prepared to give any further time for this purpose. The petition is dismissed and not prosecution. Right.
Within 3 days.
No, sorry. Yeah.
Weekly list item number 14. May I please, your lordships?
Sorry, my lord, with the liberty to file the fresh petition.
No, sorry, sir. Where is Mr. Das, Mr. Amitav Das? Where is Mr. Amitav Das, please? He said, despite a passover, Mr. Amitav Das is still not appearing. The registry will inform him telephonically to remain present at the next date. List on 19 July.
Pastor matter item number 20.
Your lordship has fixed a date, my lord.
19th July, sir. Item number 20.
Counsel not gone
None,
yet.
yeah, despite a password, none appears to the petitioner. List on. This is the same thing from Park. Vijay Patnaik Park. 14 July.
Item 20 minutes, I am appealing for the authority. 20.
No, somebody was mentioning something. Yes, sir.
Item number 2 in the weekly old matters. Today, old matter list. First list.
Item 2 is for judgment, sir.
And this matter is WPC 6761 of 2004.
So that's coming up tomorrow, sir.
My lord.
My lord, item number 23. The lordship has fixed it to 16th May. Can it be fixed to 17th May? Because
All right,
I will inform the other side.
All right.
17th. Item 23.
All right.